with regard to the Mauna Kea access road. They're absolutely correct. The assertion that the road does not belong to the Department of Transportation isn't just an assertion. It is a truth as a matter of law. I'm here in my capacity as a beneficiary, not as an employee of Hawaiian Homes, and those who cannot follow that, you got to work on that. The land is still owned by the Department of Hawaiian Homelands, as was acknowledged by our chairman at the hearing before Senator Kahele. Number two, the only way an entity can exercise any kind of management authority on Hawaiian Homelands is through a disposition with the department, one that must be approved by the Hawaiian Homes Commission. So if you're a lessee, that disposition is a lease. In the case of DOT, it would require a license agreement. So there is an existing license agreement, agreement number 676, and that is with the Department of Transportation, but that is for the easement, which is the Daniel K. Inouye corridor that goes through Hawaiian Homelands, just that portion. So if you read that particular document, it identifies all the DHHL lands in the area. Unfortunately for the argument that this means DOT has operational jurisdiction on Mauna Kea Road, it excludes Mauna Kea Road. Excludes. So, we're living now in the Trump era where you repeat the same lie over and over and over and over again. At some point, people forget it's a lie and they think it's true. DOT does not have operational jurisdiction of the road because they can't as a matter of law. So that's one way, right? If there's a disposition, there is none. The other way, which the AG is, opining, is by the operation of Act 14. So that was a law that was passed in 1995 by the state legislature after state agencies for practically since statehood was engaging in the unlawful practice of taking Hawaiian homelands without authorization from the commission and using it without compensation to the trust. That is not, an opinion. That is the result of the Federal State Task Force findings in 1983. That is also the result of the Governor's Task Force in 1994. Okay? So you had this practice of state agencies, oftentimes supported by executive orders of the governor, regularly taking, if you will, stealing Hawaiian homelands without authorization from the commission and without paying for it. The Mauna Kea Access Road is Hawaiian homelands. The University of Hawaii stole it from the trust by building a road over it and never paying for it. And they did so without authorization. They still haven't paid. So here we have a situation where you have the presence of Hawaiians on a road that was taken by the state of Hawaii, to the University of Hawaii, and never paid for. Act 14 was intended to address that situation. And if you read the act, it itemizes all the different types of lands that the state took. Does anyone know what they assessed the value for those lands in 1994? The total value of the lands that were taken from the trust? Just over $1 billion. So, you have a state of Hawaii taking Hawaiian homelands valued at just over $1 billion. And Act 14 says, we're going to settle this for $600 million. I was never good at math, but I can do that math. So the trust takes a $400 million hit. Yeah? If this was KS land, private land, and they took it, they would be subject to their exercise of their condemnation power. The standard is fair market value. So if they took $1 billion, they'd have to pay $1 billion. It was better to steal from Hawaiian Homes because they paid 60 cents on the dollar. Now getting back to Act 14, they say, the AGs is saying, the operation of Act 14 transferred all of DHHL's ownership in those lands to the state. Therefore, DOT has operational jurisdiction of Mauna Kea Road. That cannot be true also as a matter of law, because the Hawaiian Homes Commission Act, which is a federal law, identifies the process you must go through to exchange land. And one key requirement of that is you have to conduct beneficiary consultation, just like what Kalani and Kepa said. You have to conduct, not Should we talk to them now? Have to. So, I have extreme aloha and respect for our commission, but we're going through what I call an identity crisis, the commission is. It's not quite sure who it is. And despite a lot of really positive testimony to explain to them that you're not like any other state board or commission. You're treated like one, but you are not because your origin is in federal law, not state law. So if the state of Hawaii passes a state law that tells you to do something that contradicts your federal duties under the Hawaiian Homes Commission Act, you are not obligated to follow it. In fact, you have a duty to challenge it. Challenge Act 14 for being inconsistent with the following. One, the federal trust duty to protect the trust corpus, meaning the land inventory. So if the state takes land from you, you're not required to sell it to them if they tell you that's how we're going to sell this. You get to say no. That's how you protect the trust corpus. Number two, trust duty, is you have the duty of exclusive loyalty to your beneficiaries. Exclusive means you don't consider what the governor is thinking. You don't get engaged in the idea of whether science should supersede. None of that. TMT's issues are not Hawaiian Homes' issues. Hawaiian Homes' issues is only what the beneficiaries think. And if you don't ask them, then how do you know what they think? Which is to say, we're at this really critical point because, as probably we all know in this room, law enforcement is preparing for a major action. Here's the problem with that. The governor doesn't have authority on Hawaiian homelands, irrespective of the Hawaiian Homes Commission. That's the whole reason you have Act 14, right? The state kept taking action on Hawaiian homelands, irrespective of the commission. So if the governor is to proceed with this action, engage law enforcement to arrest kia'i on Hawaiian homelands, including beneficiaries, the problem with that is he would violate the authority of the Hawaiian Homes Commission. Only they can issue that order. Only the commission can. But the commission, for some reason, won't engage. And so this is my request. Please urge your colleagues at the Hawaiian Homes Commission to, one, avail themselves of all information regarding this case. And one critical piece of information is the commission acted in 1994, November of 94, and passed a motion authorizing the transfer of the lands for roads and highways, including Mauna Road. But they prefaced that transfer of authority of their ownership interest on the state complying with the settlement. That was 24 years ago. The state never complied. The state never paid the $5 million they said they would pay for roads and highways, and they never initiated the land exchange. So after 24 years, the department is announcing now that the state is going to comply. As the beneficiary, I say the deal's off the table. The deal is off. It has to be off the table. How can 24 years later? So the language of their own authorization said, if there's any form of non-compliance, any form, then the commission rescinds its authorization and avails itself of all legal remedies. And I'm urging them, so they don't even realize that there is a standing order by their own commission, by their predecessors, on the treatment of these roads and highways, particularly Mauna Kea Access Road. And so I'm asking this commission, the Board of Trustees, if they would urge their counterparts at Hawaiian Homes to please just comply with follow your federal trust duties. Recognize that you are in a compromising situation because the governor of the state of Hawaii appointed you, but he's also now trying to exercise control. The commission has to be separate. There is no reason the commission shouldn't be, the commission shouldn't be in their position through a process similar to OHA's, through the election by beneficiaries, using only beneficiary money, not public money, so you don't run into the whole rice situation where the homestead associations determine, select their commissioners. That's the only way we separate ourselves. And the last point I wanted to make is there's an inherent conflict of interest when the attorneys that advise the commission are the same attorneys that advise the people you are on the opposite table of: DOT, DLNR, Office of State Planning. That is an inherent conflict of interest. Not to say these are bad people, bad folks, by no means. But they're in a compromising situation because they advise, they're defending the legitimate interests of the state of Hawaii while giving the appearance of doing the same for the commission. That is a conflict, and that has to be, the only way that can be cured is a law that requires independent counsel for the Hawaiian Homes Commission. So please urge your counterparts at Hawaiian Homes to step up to the plate. And you know, the best way to obtain that kind of clarity of thought and courage to do that is go to the Mauna. Mahalo.